Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th, with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.
From St. Louis Public Radio. This is St. Louis on the Air.
The credibility of our authorities from both ends of the argument are at risk here because we're getting different messages and they change from week to week.
Okay, Attorney General Schmitt, if you lose and this isn't just a publicity stunt, you're going to reimburse all these school districts that you openly dislike in favor of charter schools and private schools. You're going to reimburse them out of the Attorney General's fund.
Typical kind of white male, older judges' cluelessness. I didn't think what he did was justified in any way.
Feeling that the authorities don't know what they're doing and they just keep painting with this broad brush rather than trying to address the specific needs and concerns that are legitimate for them to try to address.
I'm Sarah Fensky. If you're a St. Louis parent, you probably have strong feelings these days about Missouri's Attorney General. Yes, I am talking about Eric Schmitt, who has filed no less than 45 lawsuits against local school districts over their mask mandates. But beyond your very strong opinion and your neighbor's equally strong, possibly very different opinion, what does the law say about these kind of mandates at this time? And is there a reason that no private or charter schools got hit with one of these lawsuits? Many people are raising questions about this litigation. And so it's fortunate that today we have a distinguished panel of experienced attorneys ready to weigh in. Yes, today is our legal roundtable. And joining us now is Bill Freivogel. He's an attorney and a professor of journalism at Southern Illinois University, Carbondale. Bill, welcome.
Hi.
We're also joined today by Sarah Swadish. She is an attorney specializing in labor and employment law, and she's a partner at the law firm Sadeh, Harper, Westhoff, PC. Sarah, welcome.
Hi, good afternoon.
And last but certainly not least, today we're joined by Brenda Talent. She's a longtime attorney and was previously a partner at the firm now known as Bryan Cave Leighton Paisner. She specialized in tax law. And today she's the CEO of the Show Me Institute, which advocates for small government and market solutions for public policy in Missouri. Brenda, welcome.
Thanks for having me.
So we will talk about Eric Schmitt's lawsuits against school districts in just a moment. First, though, let's talk about a situation out of Quincy that has earned national headlines. Now, a judge in Quincy found an 18-year-old guilty of sexually assaulting a 16-year-old, but then the judge himself threw out the conviction. In a bench trial, Judge Robert Adrian found a boy named Drew Clinton guilty of felony assault. But at the sentencing, the judge heard post-trial motions, and then he said he would not impose the mandatory minimum of 4 years in prison. Mr. Clinton has served almost 5 months in the county jail, Judge Adrian said, according to a transcript of the hearing. For what happened in this case, that is plenty of punishment. That would be a just sentence. Now, there's a lot of talk about how mandatory minimums handcuff judges. Sarah Swadish, do you think that was a fair way around the minimum sentence he would have been required to give out in this case?
Yeah, mandatory minimums. I do believe that judges should be permitted discretion. There are mitigating circumstances that can make an offense different, and maybe the sentence should be less than a mandatory minimum. So I'm not offended that he deviated from the mandatory minimum, but I was certainly offended with the result of that deviation. So the backstory, the girl was 16. She drank alcohol. She swam in her underwear in a pool, got out of the pool, passed out, and she woke up to Mr. Clinton, the defendant here, smothering her with a pillow so that she couldn't breathe, and she managed to escape. So would I agree with 5 months in the county prison? Absolutely not. But am I offended by the fact that he deviated? No, I think judges should be given that discretion.
Bill Freivogel, is there a way he could have worked around this mandatory minimum other than just chucking out this entire sentence, saying, hey, this time in the county jail, that's enough?
Well, I think he could. I don't really know the answer to that. I mean, I think he could have imposed a lighter sentence, and then there could have been some sort of appeal as to whether or not he had enough criteria for doing that. But to find instead the young man not guilty after having found him guilty, and to basically be minimizing what had happened to this young woman, who was, I mean, it seems to me the circumstances are she was being raped while she was passed out. Mm-hmm. I mean, to minimize that in the way that he did, and say it's 100 days is enough, or I mean, I thought that was just sort of a typical kind of white male older judge's cluelessness. And so I didn't think what he did was justified in any way. I noticed that there's a petition circulating to have him receive some sort of discipline for that. I don't know whether that will occur. Of course, he also got mad at the defense lawyers tweeting about what he had done, and
yeah, I mean, there's a second part of this. There was a Facebook post, and a local prosecutor apparently liked this Facebook post that was critical of the judge. The judge threw him out of his courtroom. He said, "I can't be fair with you. Get out." Brenda Talent, what do you make of all this?
Well, at least he was honest with the prosecutor. Whether that's judicial temperament or not is a different question. I mean, you would think that a judge would be thicker skinned and would recognize that people would have problems with the decision he made. I mean, one of the things I throw out based upon my reading of Illinois law is I believe this judge is going to be up for retention this year. So unless he gets 60% of the vote, he won't be retained. And they've also moved him out of felony cases. So because of all of the national attention regarding his decision, I think in both instances, in throwing out the conviction and in telling the prosecutor, because you liked a Facebook post, you can't appear before me because I can't be fair.
Yeah, I mean, I've heard some regulars on this panel say at some points that they're worried about expressing disagreement with judges' rulings. They feel like they might privately think that a judge got something wrong, but they don't feel comfortable saying that even on the air because they're worried that this might upset a judge or that this might go against some rules of judicial conduct. Brenda, where do you see the line on all this?
We actually have ethics standards where we're not supposed to make a statement that we know is false or with reckless disregard concerning the qualification of integrity of judge. I think it's sad that we feel hamstrung, that we can't be critical of decisions. It's sort of like, I'm not saying you're a bad person, but that's a bad decision. We do worry about the integrity of the judicial process. And part of that integrity is having the professionals being able to discuss whether those standards are actually being observed or not. When I hear the concern about voicing criticism of judges, I think of parents in schools saying, well, we don't want to be critical of the teacher because they might take it out on our kid. And for professionals, to me, that's a sad place to be. Unfortunately, I do think it is a reality in today's world.
Bill, what do you make of all this? I mean, do you think that, this whole thing about a prosecutor liking this post critical of the judge, was that something the prosecutor shouldn't have done?
I think the prosecutor had every right to do that. But it is true that, I mean, lawyers don't have as much First Amendment protection for their speech about judges as, say, newspaper reporters. Mm-hmm. We actually have a case 30 years ago. There was a case right on this issue. Buzz Westfall, the late Buzz Westfall, when he was prosecuting attorney before he was county executive, criticized a judge in a very emotional case involving a husband who had murdered his wife or killed her. And Westfall said in a KSD interview that the judge who wouldn't allow a subsequent prosecution was dishonest. He later said, well, he meant intellectually dishonest. But nevertheless, he got, first I think he was suspended and later it was reduced to just a reprimand. But the court made very clear that he didn't have a First Amendment right to do that.
Mm-hmm. So, Sarah, there's a lot of issues on the table here that we've been chewing over. One of them, Bill referred to sort of the white male cluelessness of what this judge was up to. This other issue of how critical one can even be of judges. I can see the overlap between what Bill just said and what I'm about to ask you. But what are your thoughts on all this?
Sure. So I guess to the first point of the judge deviating, when I first read what happened with this judge, I was shocked and appalled, but then I was embarrassed for myself that I was shocked and appalled. Brock Turner, 2015, caught raping a girl in an alleyway, and the judge threw it out and said, well, he's a young man at Stanford and he deserves a second chance. It happens regularly. And so it's shame on us for being shocked that a judge would say, well, he's a young man and he deserves a second chance and he's too young to know what he's doing. And so, yes, I would agree there is a lot of male privilege happening here with these convictions getting thrown out because they don't want to punish these young men. As far as the judge being disappointed or aggravated with the prosecutor for liking a Facebook post that's critical of him. Again, I was sort of just I was irritated. I was absolutely irritated that a judge would have such thin skin that somebody cannot like, or somebody would like a post that's critical of you. Just impossibly thin skin. But my second thought was, don't be a hothead. Think about what's happening with this judge. And I thought, it's the unknown bias that scares me the most, right? And at least this judge had the honesty to say he actually said to the prosecutor, I can't be fair with you. Get out. And I have a lot of respect for that. While he may have thin skin, I have a lot of respect for the judge who can say, I can't be fair with you, recognizing that his client, criminal defendant or the state or whomever it may be, deserves a fair chance in front of him. And he says, I can't be fair, get out. And frankly, that's what we want in our judges. I mean, I've spoken to a couple of attorneys about what they've been on the selection panels to help pick judges. And they say, we want judges who are smart and have done complex litigation and who know the laws and have good integrity. But what they've said to me is we want judges with a good temperament, somebody who doesn't have thin skin, somebody who will be courteous to a pro se plaintiff who doesn't know what they're doing, or pro se defendant who doesn't know what they're doing, somebody who will allow the attorneys to make their arguments, even if they've already heard it before. They let the attorney make the argument again. And at some point, the attorney will get cut off, but they have the temperament. And so, I can appreciate this judge was frustrated, but it's the judge said, I can't be fair, get out. And that shows a lot of integrity not to hold this unknown bias against the attorney.
Bill, I'm going to give you the last word on this one.
Okay. I mean, I'm not as forgiving as Sarah on this. I mean, that the judge, we'll give him a break because he was honest that he couldn't be fair. I mean, his judicial temperament in this entire case is at question. And I'm glad we're shocked at what he did in this case. And I'm glad that we were shocked in the Stanford swimmers case as well. I mean, that judge isn't the judge anymore. And I don't think this judge should be a judge anymore. But maybe it'll be the voters who make that decision.
When we come back, we're going to talk about Attorney General Eric Schmitt's fight against mask mandates. This is St. Louis on the Air on St. Louis Public Radio. And now back to our legal roundtable. Our panel today includes Sarah Swadesh, who's an attorney specializing in labor and employment law. She's also a partner at the law firm Sadeh, Harper, Westhoff, PC. We're also joined by Brenda Talent. She's the CEO of the Show Me Institute and a specialist in tax law. And also we're joined by Bill Freivogel, who's an attorney and a professor of journalism at Southern Illinois University, Carbondale. Now, I want to talk about something here that has gotten a lot of attention in the state of Missouri. Many parents, many armchair quarterbacks have a lot of thoughts about this. In the course of a few days this past month, Attorney General Eric Schmitt filed no less than 45 lawsuits against school districts saying their mask mandates were illegal. Brenda Talent, what kind of case is he making in this blizzard of lawsuits here?
Well, first, I think out of just being absolutely clear for disclosure purposes, my son is actually a deputy solicitor general in the Attorney General's office, and he's involved in these cases. But I haven't read his brief, so I'm just going to talk generally about the law. My understanding, and I welcome the other panelists to join in, is really the question is whether the school districts have the authority to exercise the ability to actually issue these mask mandates. I mean, we've got a statute that was enacted by the legislature last year, 67.265, that has particular requirements that need to be satisfied. And when you have school districts stepping in, I think the question is, there's something called the Dillon Rule, and it's a principle that you can only exercise authority that's been expressly granted by the state. Are the powers that you're exercising necessarily and fairly implied from that grant of power? And are the powers crucial to your existence? And, of course, school districts are creatures of state statute. And so my understanding is that's what these lawsuits involve, whether they're properly exercising their authority under their general statutory provisions and whether there are limitations upon that authority based upon the law enacted last year by the legislature.
So, Sarah Swadesh, do you think this is a reasonable question for the courts to decide at this point, whether school districts have the power to do this, or is it clear-cut one way or the other?
Well, I think it's clear cut. The schools absolutely can do it. They have the right to decide vaccines. If kids have the DPT vaccines before they enter school, the cleanliness, the sanitation of the cafeterias, I think they absolutely can decide if students or faculty are mandated to wear masks. And the statute that Brenda referred to, 67.265, the state legislature tried to limit the authority of health officers, local health agencies, or public health authorities. That's not a school district in my mind. So I think our state legislature, in an effort to block mandates, this and let's be honest, this statute doesn't have anything to do with anything else in our atmosphere. There's nothing else going on. This is exclusively our Republican legislature trying to stop mask mandates. It's not about anything else. And they developed this statute too hastily, and I think they left out key components. And I think it was sloppy work by them to try to interfere with our school districts, and they didn't do it well.
Brenda, do you think
I think the school districts retain the power to enforce mask mandates or to create them.
Brenda, do you think if the legislature wanted this to apply to school districts, would they have to have made that explicitly clear? Or do you think we can presume, okay, they're talking about health authorities, this should count?
Well, actually, I do think the statute has some drafting issues, but it does talk about political subdivisions. School districts are considered political subdivisions, and there are specific references to various kinds of industries, businesses, and schools. So, but there's other language in there, I guess, that I would say is problematic from the standpoint of drafting. So, when you look at it, there's a part of me that goes, I don't think you intended to word it this way. You should have worded it differently given what I think you want to achieve. So, that is proper, in my opinion, for the courts to determine. I also think another issue here is one where these sort of broad, and this is more from a policy standpoint, is that a lot of this stuff could be more narrowly drawn, particularly in light of the evidence we have coming out about learning loss. there's a lot of efforts by authorities to paint with a rather broad brush rather than trying to tailor what they're directing to specific needs. And I think that's part of what we see is when we hear these rather robust debates by parents about what their schools are mandating or not mandating. That's what's happening. There's a feeling that the authorities don't know what they're doing, and they just keep painting with this broad brush rather than trying to address the specific needs and concerns that are legitimate for them to try to address.
You know, hearing this discussion as you're talking about, political subdivision, this is why Brenda argues this should apply to school districts. Sarah argues that it doesn't. That answers a question for me that I've heard a lot of parents talking about. If Eric Schmitt doesn't like these mask mandates, why isn't he also suing private schools that have them? It seems like the answer is pretty clear cut here, Bill. He could only sue public school districts over these kind of policies.
Yeah, I think that's true. I mean, I think that private schools have their own freedom to run their school as they choose. There's all sorts of constitutional requirements that don't apply to private or parochial schools. But Brenda says there's this sort of like really sort of broad, wide-ranging discussion, and I think that Attorney General Schmitt has really contributed to the not very healthy debate that is going on about mask mandates in schools. I mean, first of all, you would hardly know from his legal filings that the CDC recommends that there be masks in schools, the Attorney General sent these messages to school districts all around in December 8th of 2021, last December 8th, saying, illegal mandates, report your school district's illegal mandate. And some of the parents then, Riverfront Times had a good story about how some of the parents then would go, with this a printout of Schmitt's request for information on these illegal mandates. They would go to school and say, the Attorney General says this is illegal. You can't make my child wear a mask. I mean, that I really think was I think it was irresponsible. I think a lot of what Attorney General Schmitt has been doing is irresponsible. From his ridiculous lawsuit in the Supreme Court involving the last election to his witch hunt for anybody in Springfield school district who might be teaching critical race theory. I think his handling of this has been highly irresponsible.
Sarah, going back to the mask mandates and the litigation over that, what are your thoughts on this?
Right. Well, as far as the charter schools, I think they've been omitted by design. I think there's always been a push for charter schools away from public schools. And so I think the omitting or the exempting the charter schools from the mask, from being sued in these lawsuits was certainly by design. But I think Schmitt's lawsuit also sort of ignores the reality that most of these schools have been closed one or more days because of COVID, because I think they're saying it's above 3% of the student population is out. And the CDC, as Bill's saying, says masks work. And I think it also ignores that it was 40 members of the U.S. Navy just landed in St. Louis to help the hospitals in St. Louis because of the COVID surge. And so Attorney General Schmitt claiming that masks don't work and they're ineffective sort of belies what's really happening, which is the U.S. Navy had to send in 40 members of a task force to help our overrun hospitals. So, yeah, I think this also gets to what Brenda was saying. Are some of these statutes overly drafted? They're too broad, and I think so. And I think it ties into a case coming out of the 8th Circuit in Iowa, where the 8th Circuit have sort of said the same thing of Brenda, which is, these statutes are just overbroad. They're not tailored in any way.
So
Yeah,
I'm glad you brought up this case out of Iowa. This was the Eighth Circuit Court of Appeals weighed in on this. And basically, they heard the appeal of a lawsuit contending that Iowa's ban on masks in schools violates federal disability law. The Iowa parties contended that the law requires accommodations for their children who have disabilities that put them at risk of severe complications from COVID-19. And the Eighth Circuit seemed to say, like, yes, this is a fair consideration. It made me wonder if there might be applicability here where we have the Attorney General. One of the districts he's suing is the special school district that has to deal with students that have special needs. Brenda, is this potentially a ruling that could give some trouble to that particular lawsuit? Just one of 45 of these lawsuits, it's fair to say, but that one.
I think it does, but I think it highlights both sides of the equation here. So if a child is with disabilities or who is vulnerable to the COVID virus, it needs to be protected. And so what Iowa, the Eighth Circuit was saying in the Iowa case is, look, you can't ban them if you have students who have particular needs and people should be masked around them. You've got to allow that. So you have to tailor your law to that effect. And so the opposite works here too, in the sense of, in Missouri, look, we've had a lot of learning loss. Part of it is because kids, first of all, they may not handle wearing the mask very well. They also may have, and these are kids without disabilities, may have issues in learning, in interacting, et cetera. I mean, we've seen sort of a whole range of particular kinds of negative consequences from masking for children at various age levels. And of course, there obviously should be carve-outs for disabilities, for religion, for other types of necessities. So again, all of this, even when you're looking at the school districts, you want to say you need to tailor what you're trying to do in order to address the concern that you say you're trying to address. So I just think a lot of this also, in my opinion, when we have the robust discussion by parents, is the fact that we get mixed messages. So we hear masking is effective, but then we hear, well, kids don't do masking correctly, and if you don't do it correctly, it doesn't help you. And cloth masks don't work, but we allow cloth masks. So again, when I look at this entire picture, I just feel like the credibility of our authorities from both ends of the argument are at risk here because we're getting different messages and they change from week to week.
So beyond these different messages that are changing, I'm wondering about all these different jurisdictions that are now hearing roughly the same case. And I understand that when all this started, the Attorney General was trying to do a class action lawsuit. And at that point, our panelists were skeptical that that was the right mechanism. But it honestly hurts my head to think about 45 different lawsuits proceeding on this, much less the fact that in many cases, taxpayers are paying for both sides of that. What if we get 45 different rulings coming out of this? I'm also thinking about this Eighth Circuit opinion that we've been talking about. You know, they looked at this issue of kids with disabilities. Previously, the ACLU of Missouri tried to intervene in one of them and was told they couldn't intervene in this when they were trying to push this same thing. This is making me feel that the law is broken and that there's just no clear-cut path forward on this. Can any of you defend all the confusion we're in? Bill, I would love to hear a defense.
I think you've given a good description about what a mess has been created. But I would like to say a good thing about Dwayne Benton, who wrote the Eighth Circuit opinion. I mean, this is a former Republican politician in Missouri, and his opinion is a really excellent, careful, narrow opinion that says basically Iowa's mask mandate doesn't even really reach cases where kids with disabilities have got problems that require the school to be masked, and therefore it can't be enforced in many of the schools in Iowa. And he wrote a very nice, narrow opinion that looks specifically at the situation involved. You asked earlier, well, is a special school district, surely, this applies there, but it applies to the ADA issue applies to any school, public school.
So now,
in the
Bill,
state of Missouri.
So now do kids who have special needs, do they need to come in with a letter to show their school district to say, here's this Eighth Circuit ruling? thing. I mean, this seems like a nightmare for school districts, that nobody knows which end is up right now.
It certainly is a nightmare, particularly when, parents show up with something from the Missouri Attorney General's office saying illegal mandate that your school district is enforcing.
Yeah, so this is a big can of worms. And I guess I'm wondering, Sarah Swadesh, we've got these 45 different courts. Say that one judge rules that, this mask mandate, this stands. The other one rules it's got to go. Is this automatically heading to the appellate court no matter what happens in these 45 different theaters?
Well, hopefully these cases get consolidated so that we don't have 45 different opinions. Hopefully they are all brought together. And I would imagine that most of the school districts are making the same arguments. They're pointing out the statutes that do give them the explicit authority on this issue. So hopefully they do get consolidated. And as recently, I think as last week, there was a bill filed in the House and a similar bill filed in the Senate that essentially says loser pays. Attorney General, loser pays, meaning if the school districts win, the Attorney General has to reimburse all of the school district's attorney's fees out of the Attorney General's budget. So, right? Because right now the school districts are paying, all these 45 school districts are paying for attorneys, which is taxpayer money, and Attorney General Schmitt's lawsuits are all taxpayer money. We're really cannibalizing themselves. And so these bills that are introduced in the House and the Senate say, okay, Attorney General Schmitt, if you lose, and this isn't just a publicity stunt, you're going to reimburse all these school districts that you openly dislike in favor of charter schools and private schools. You're going to reimburse them out of the Attorney General's fund. I can tell you, I believe both bills are sponsored by Democrats, and the Republicans, none of them are signing on or excited for this. In my world, we call it loser pays. Whoever loses the lawsuit has to pay the other one's attorney's fees. And I'm a fan of loser pays.
It's hard to argue with loser pays. I can see this having a tough road in the Missouri House and Senate. I don't think they're going to necessarily get on board on a Democratic effort to make the Attorney General pay for this. Bill?
I have a non-legal observation to make, and that is that when I opened up my Webster Kirkwood Times last week, it was filled with letters to the editor criticizing Schmitt for suing the Kirkwood School District. And, Kirkwood was his political base. I mean, maybe I don't understand the politics. I confess, I do not understand the politics of the current Republican Party. But, how a person who grew up in Kirkwood and whose political base is Kirkwood can be taking a position which, at least seemingly, is very unpopular in his home political base.
But Bill, at the
he's
same
obviously
time,
playing to a different
Bill,
group.
in some of these suburban St. Louis school districts where there's a lot of Democratic voters, yes, these are deeply unpopular. But I think, you referenced the RFT story. There are a lot of parents that are behind this. I imagine that once you get into different counties or even different municipalities, this is a very popular thing for him. Some parents are pretty fed up about this, and it's been interesting to see his poll numbers rise. I don't know. I mean, I recently saw some poll numbers in the Missouri Senate race. He's on the ascension here. I know there's a lot of controversy and different people feel different ways about this. But Brenda, it seems like maybe there's another side of this argument where in some districts people might perceive him as a savior.
When you listen to parents, we're talking about their children and their children's education. People get emotional about that. And for a lot of parents, the lockdowns, the virtual learning online, it didn't work. And they're very concerned about their kids and about their kids catching up and their kids being competitive, their kids having opportunity. And when you look across the spectrum, and it's not limited to one socioeconomic level, these are moms across the spectrum who are very concerned about that. And so, again, those emotions are running high, and when you talk about learning loss, people get very concerned about these mandates and what's happening with their kids, not only with the masking, but actually what's going on in the classroom too, with how they distance, how they socialize. So I think you're touching a core issue for parents, and they're going to feel very strongly one way or the other, and they're going to voice that.
We have more legal discussion, a whole bunch of more cases to talk about today coming up next. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. Today is our legal roundtable. There are a whole host of legal issues to discuss. We're talking to Brenda Talent, who's the CEO of the Show Me Institute and a specialist in tax law. We're also joined by Sarah Swadish, an attorney specializing in labor and employment law and a partner at the firm Sadeh Harper Westhoff PC. And we're joined by Bill Freivogel. He's an attorney and a professor of journalism at Southern Illinois University, Carbondale. Now, we've been talking about the Attorney General's office fighting against mask mandates. Well, lawyers for that office also recently argued at the U.S. Supreme Court in a little case called Biden versus Missouri. Now, the feds announced last November that in order to receive Medicare and Medicaid funding, participating facilities must ensure that their staff are vaccinated against COVID-19. There were exceptions for medical and religious reasons, but other than that, people had to get those vaccines. Now, in both cases, appellate courts stayed the rules. So that brought us to the Supreme Court. Here's Sonia Sotomayor questioning a deputy attorney general for the state of Missouri. This is Jesus Osete.
I'm having a very hard time understanding how you can say, yes, they could pass a rule that requires people to wear gloves, or they could pass a rule that requires them to isolate individuals who are infected by something. But they can't pass this rule, and you say because it wasn't clear? If it's clear enough that they can consider safety and health regulations, why is this particular rule subject to us saying no?
Because, Your Honor, this court in Jacobson in various cases has drawn the line at compulsory vaccination being something that the states do. And when Congress enacted
wait a minute. That's what they do with respect to other issues. But this is with respect to if you want my money, your facility has to do this.
Sure.
It has to have, it has to serve certain food. It has to serve certain meals a day. It has to give snacks. These are all state issues usually, but under the spending clause, we're the buyer. The federal government says what it wants to spend its money on. This is not an issue of power between the states and federal government. This is an issue of what right does the federal government to dictate what it wants to buy?
Your Honor, it is a vaccine requirement masquerading as a condition of participation. And if Congress intended that, this court has made it very clear that something like compulsory vaccination, even in the spending clause context, which itself demands Congress to speak with a clear voice, it requires...
How much clearer do you need for Congress to say then pass regulations that protect the health and welfare of ill people?
So that is just a short excerpt from the U.S. Supreme Court as it heard the case Biden versus Missouri. Bill, is that basically what happened here? This ended up being the key question that Sonia Sotomayor is drilling in on.
Yeah, it did. And the state of it's the scary thing to me is that 4 justices of the Supreme Court said no. The federal government didn't have the power under these circumstances to put these regulations into effect.
I guess I was curious, we have a conservative Supreme Court. Missouri couldn't win all the conservative justices.
No, Chief Justice Roberts and Justice Kavanaugh came over to the democratically appointed justices' side in the argument. It was a per curiam decision. Justice Breyer, who just announced his retirement, he was apoplectic in the same argument. He said at one point, It seems to me every minute that these things are not in effect, thousands of people are getting this disease. And you tell me I can't take that into account? To me, that's fairly unbelievable. And that's sort of the way I see it. The per curiam opinion ended sort of this happened the same day that the Supreme Court threw out the OSHA mandate, and the per curiam opinion, in other words, opinion for the court, is what that means. It probably was written by, I'm guessing it was probably written by Chief Justice, says the challenges posed by a global pandemic do not allow a federal agency to exercise power Congress has not conferred on it. At the same time, such an unprecedented circumstance provides no grounds for limiting the exercise of authorities the agency has long recognized to have. And that's what was the case in the Missouri case, that this was this had been authorized for forever.
Brenda Talent, where do you think Missouri lost Judge Kavanaugh, Justice Amy Coney Barrett, people who might have ideologically been on their side but ended up not getting on board for their argument here for vaccine against vaccine requirements?
It's sort of what would you call it, black letter law? I mean, when you've got statutes and you've got rules and regulations, where the statutes indicate that they want to provide the authorities to issue rules and regulations, there's a deference to that exercise of authority. And I think here that when I look at the two cases, the one involving OSHA versus the one involving Medicare, to me that's the distinction. There was language in the Medicare and Medicaid statutes that would allow the justices to hang their hat on it and say, you're exercising authority that has been granted to you as experts to exercise. Whereas in the OSHA cases, they couldn't find that language to hang their hat on.
So that was in front of the Supreme Court. Didn't go that well for Missouri, but these vaccine mandates, there's places where you can have them, places where you definitely can't have them. We've been talking a bit about the Eighth Circuit today. Well, they issued a new ruling in a St. Louis case. This comes out of a lawsuit filed by having to do with the protests after former St. Louis police officer Jason Stockley was found not guilty. Many people out that night, including journalists and documentary filmmakers, were rounded up and they were arrested. The cops used a technique called kettling that kind of just pushed everybody into an area. Everybody who was there ended up getting arrested. Now, a man named Brian Bowdy left his home at 9:30 that night, apparently unaware that police had given orders to disperse. He ended up in a kettle. He was pepper sprayed, zip-tied, held for 14 hours. He sued, saying his civil rights were violated. The police officers filed a motion to dismiss. The lower court judge declined to do so, so the police officers appealed. Now the appeals court weighed in on that decision. Sarah Swadesh, what do we take from their ruling here?
This does not bode well for the city. We call it 1983 work, and holding police and police officers accountable for misconduct is exceptionally difficult. It is hard to do. The legal threshold for proving your claim is high, and qualified immunity generally means that if an officer did something wrong, he probably won't or she probably won't be found liable because they have immunity for many of their discretionary acts. Did they pull the car over? Should have they arrested somebody? Should have they shot somebody? Maybe, maybe not. It depends on the circumstances of what's happening. And police officers are given a lot of deference from the courts on how to be a police officer. And the officers in this case essentially sought a dismissal based on qualified immunity, and the Eighth Circuit came in and said no. I want to read a blurb. They said the pleadings before us and the video evidence paint a picture of a compliant individual among a generally peaceful and compliant crowd who was boxed into an intersection, pepper sprayed, and forcefully arrested. That does not bode well for the city or its police department, because the Eighth Circuit is generally conservative, and the Eighth Circuit will generally stand by the police. They will grant them immunity. And the fact that the judge denied it and the Eighth Circuit affirmed it, these officers are going to go to trial on whether their conduct was appropriate. And I believe they argued, well, it was reasonable because it's what our supervisors ordered us to do. And the Eighth Circuit said, yes, if you follow your supervisor's instructions, you can have qualified immunity. But while you're following your supervisor's instructions, if it's not reasonable what you're doing, you don't get qualified immunity. And the Eighth Circuit said, even if you were instructed to do this kettling and pepper spraying, it wasn't reasonable. Mm-hmm. So I think the city's in trouble. I think these officers are in trouble. And I wouldn't be surprised to see a settlement in the certainly next year.
Yeah, I mean, when you said this means they're going to trial, or it means that there's going to be a lot of money being paid to settle this case. I mean, Bill, this is a very bad ruling for the St. Louis police.
Yes, it is. I mean, this was a very ugly night for the St. Louis police. I mean, remember, this person comes out of his house. He's concerned that maybe there's some damage, to the air from the protests in the area around him. He comes out and then he sees what's going on. He tries to get out of this kettle. The order to disperse. Most of the people in the kettle hadn't heard it because it occurred blocks away from where this was. People tried to get out of the kettle and were not allowed to. The police threw a black man into the kettle. This is the same night that the white police officers beat up their undercover colleague in a somewhat related incident. But qualified immunity, it doesn't bode the end of qualified immunity. I'm sorry to say, qualified immunity is this get out of court free card for police. Makes police accountability almost impossible. It says that even if a police officer has violated the constitutional rights of a citizen, that if the police officer didn't know that was a clearly established right, that then he or she still gets off. And I think maybe given the facts and the Eighth Circuit decision is interesting, but it's going to come down to the Supreme Court deciding whether to cut back on qualified immunity, and they've made pretty clear they're not planning to do that.
So at this point, police need to be careful. In light of this ruling, you have to be careful with the kettling. I want to squeeze in one last short discussion here today. Back in the news, Mark and Patricia McCloskey. They gained some national fame after waving their guns at protesters. Circuit Attorney Kim Gardner brought felony charges. They pled to misdemeanors and agreed to turn over their guns. Well, Governor Mike Parson pardoned them. Now they want their guns back. The Post-Dispatch had a great quote from Robert Dierker of the city councilor's office. He admitted the city hasn't got around to destroying these guns yet. Quote, obviously with our customary efficiency, we should have destroyed the weapons months ago, Dierker said. We haven't. So McCloskey's a beneficiary of bureaucratic, I want to say, ineptitude. These weapons still exist. Should they get them back? I'm going to ask each of our panelists for their thoughts on this. Sarah Swadesh, let's start with you.
The short answer is no, but when I read this, I thought this is a sadder 2.0 version of Schmitt filing lawsuits to be in the spotlight. I thought he didn't care about these guns. He just needs something to get in the newspaper. So he's filing a lawsuit for attention, just like Eric Schmitt, but it's a sadder version of it.
And we should point out,
you don't get he pled guilty. Part of the plea was you lose your guns. That's a contract, my friend. You're not getting them back.
And we should point out these two are running in the same Senate race. Republican voters will have the choice of whether to vote for Mark McCloskey or Eric Schmitt. They can decide which of the two they find sadder, if they find them sad. We don't know. Brenda Talent, do you think there's an argument that they should get their guns back?
I would agree with Sarah that this would seem to me to be a question of contract law, because I don't know that a pardon lets you go back and say, oh, I'm going to undo all of this stuff, like if you forfeited property, et cetera. So the short answer is I don't really know the answer, and why doesn't the city get its act together?
Yeah, they had destroyed these guns, right?
Agree.
Brenda. We could do an entire legal roundtable on why doesn't the city get its act together. Bill, it's hard for me to believe you're going to come down in favor of the McCloskeys getting their guns back, but I want to give you that chance to surprise me.
Well, I don't think they should get them back as a matter of my personal opinion, but, maybe the pardon does vacate I don't know if that vacates a guilty plea, and so maybe they get them back. Yeah, let them have them. Just stay away from Portland Place.
Well, Bill will not be walking.
I'm going to jump in. I have to jump in, Sarah. That's a privileged statement. There is no other crime if somebody sold or had a little bit of crack or heroin on them 15 years ago, and a governor came in and said, you know what, I'm going to pardon you. The sentence was too harsh. We're going to give you your gun back. There is no way. That is a privileged blessing for for somebody like McCloskey. No, he's no better. He does not get them back. I'm sorry to jump in and say no.
And I got to say, in the last word here, say this did happen 15 years down the road, I fully believe the city would not have gotten around to destroying those guns yet. It would not be a moot point. So, look, I want to thank our panel for joining us today. Sarah Swadish of Sade Harper Westhoff, thank you.
Thank you.
And Bill Freivogel of Southern Illinois University Carbondale, thank you.
Thanks.
And Brenda Talent, CEO of the Show Me Institute, thank you.
Thank you, Sarah.
Today's episode was produced by Sarah Fensky, with audio engineering and podcast design by Aaron Dorr. Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri, St. Louis.
Support comes from the Missouri Forest Products Association, honoring Arbor Day on April 26th, with an ongoing commitment to sustainable stewardship and conservation of Missouri's forests. ChooseWood.com.